Good morning, everyone, and welcome to today's Beasley Allen webinar, Professionalism and Ethics. I'm David Byrne, and it's my pleasure to introduce our two very distinguished speakers for this year-end CLE topic. Today, I'm honored to welcome Alabama State Bar General Counsel Roman Shaul and our immediate past president of the Alabama State Bar, Beasley Allen Principal Gibson Vance. So together, Roman and Gibson are going to examine the State Bar's disciplinary process, while also emphasizing expectations within an ever-evolving technological landscape. They're going to discuss proposed rule changes and their implications, and they're going to talk about a really hot topic right now, that's artificial intelligence, how it's being used, and what are the ethical implications of AI. Now, while we're waiting on the last of our registrants to join us, I'm going to take just a few moments to introduce our two speakers. As most everyone knows, Roman Shaul has served as the Alabama State Bar's General Counsel since 2018. Before that, he served as a circuit judge for Alabama's 15th Judicial Circuit, and he spent over 19 years in private practice in firms both in Tuscaloosa and in Montgomery County. During his time in private practice, Roman was the president of the Alabama Bar's Young Lawyers section, and in addition to his Alabama Bar admission, Roman's been admitted to practice in a number of states, to include Arkansas, Georgia, Louisiana, Mississippi, South Carolina, Tennessee, and West Virginia. Roman's a tireless supporter and advocate for our state bar members, and I really want to emphasize that. He provides a lot of support for our members. We couldn't be more delighted to have him on today's program. Turn next to Gibson Vance. What can I say about Gibson? He is a longtime member of Beasley Allen's personal injury and consumer fraud sections. During the course of his career, Gibson's handled dozens and dozens of highly successful jury trials, and in his spare time, he's managed to hold just about every top position that a lawyer can have at the county, state, and national level. Gibson has served as the president of the Montgomery County Bar Association. He's been the president of the Alabama Association for Justice and the president of the American Association for Justice, and he's our immediate past president of the state bar. On top of all that, Gibson was elected president pro tem by the board of trustees for his alma mater, Troy University. I am extremely honored to call Gibson Vance my friend and my law partner, and I'm very happy to have him join us for today's webinar. So before I turn the program over to our two speakers, I do need to go over just a few CLE-related notes. First, today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. Now, in order to receive full credit for attending, you've got to stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have all gotten when you registered, but no worries, by the end of this week, you're going to get another email with an evaluation form and an updated presentation and video link with all the slides. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded, and for those Alabama and Georgia attorneys participating today by phone, please email us your name, phone number, and state bar ID number. Send that again to webinars@beasleyallen.com. That helps us ensure that you get full CLE credit. Also, want to remind everybody, check out our events page. It's on our website at beasleyallen.com events, because we're going to be adding more webinars in the coming year, 2024. Hard to believe we're at year's end, but here we are. Last but not least, if you have questions during today's webinar, I want to encourage you to use the question and answer feature located at the bottom of your screen. We're going to set aside time at the end of today's program, and we're going to try to tackle the questions submitted by all our viewers. So with that very long introduction, Roman, Gibson, let's get started with today's program.
David, thank you. Thank you for that very kind introduction. Roman, thank you for being here. As most of you know, we have 20,000 lawyers in the state of Alabama, and Roman is in charge of the regulatory functions for those lawyers. But in addition to that, he's also very busy traveling across the state, presenting CLEs like he is today. Roman, you've had a busy month.
I have. Yeah, this is a busy busy time of year for us. You know, my office does two things primarily. Most people associate us with the prosecution side. We certainly do that. But the other part of my office is our ability to give lawyers ethics advice. And so as part of that ability to give ethics advice, we speak at a lot of CLE presentations, and this is certainly our busy year. I think I told our board when we were 40 days out, we had a meeting, and I made the comment that I was scheduled to speak 35 times over the next 40 days. Oftentimes that's 2 or 3 CLEs a day. So, but I enjoy it. It's one of the reasons I took the job, to get out and talk to lawyers, lawyer organizations. And so I really enjoy that. And so thanks for having me.
Absolutely. Let's get started.
Yeah. So what I'd like to do is tell you a little bit about my office. We'll ease into some other topics. And as David pointed out, there is a question and answer function on the Zoom call. And so I'm going to talk about some things that I think are important, but really what I'd like to talk about is anything that you think is important. So if there's anything that you see that you want to talk about, then please let me know. And I'm happy to answer any questions that you have. So at a high level, last year, 2022, we received 897 bar complaints against lawyers. Now, a lot of times those come in from disgruntled clients. Sometimes they come in from opposing counsel or your judge. Sometimes we get anonymous complaints. Maybe someone gets arrested or whatever. However we receive the complaint, we are required by rule to send it to the lawyer. The lawyer is required by rule to respond. And I know sometimes that's a frustrating process. We understand that, but the rules require us to send it out and require you to respond. We always give you more time when we can. And so when we get the lawyer's response, at least 2 lawyers in my office will review that lawyer's response. So we have the complaint on one hand, the lawyer's response. We typically within a year, will screen out 74 to 75% of all complaints within a 14 to 21 day period after we receive the lawyer's response. And so when we get the lawyer's response, if we can tell that there really is no merit to the case, we'll screen it out. Last year, we screened out over 90% of all complaints within that 14 to 21 day period. And so I try to make that point because if you look on the statistics, it says 870. So people say, Roman, what'd you spend a lot of your time doing last year? I spent a lot of my time telling 870 people that their lawyer didn't do anything wrong, that their lawyer got it right, wasn't their lawyer's fault. And I spent a lot of time defending lawyers in the legal practice. The other thing that I would say that my office does that I'm very proud of is if you see the bullet point where it says informal opinions issued, we issued 2,250 ethics opinions to lawyers trying to help them, trying to help their clients. And so that's probably, in my opinion, the best service the bar offers, the membership. And so something we're really proud of.
So Roman, let's talk about the informal opinions. Tell our people pragmatically how that works.
So pragmatically, my office is divided into 2 divisions. You have the disciplinary division, which are the 3 prosecutors, and then you have the ethics division, which is staffed by our ethics counsel, Trip Vickers. But both Trip and I can issue ethics opinions. And so if you call us to get an ethics opinion, that is a confidential call, which means we will not tell your senior partner or anybody else in your law firm. We won't tell your judge. We won't tell opposing counsel. And if we uncover some type of unprofessional conduct, we don't tell the prosecutors in our office. The rule says it is a confidential call. And so we will treat that confidentially. If you give us a full and fair disclosure of what your facts are, we'll give you an opinion. And if you follow our advice, we won't prosecute you. That's about as good of a get out of jail free card as we can give you.
And it's free.
It's free. That's right. If you call some bar associations and you ask for an ethics opinion, they'll charge you for it. Not us. It's free. It's always been free. That's the way the Alabama Supreme Court has designed it. They put the confidentiality provision in there to encourage lawyers to avail themselves of this. And it's part of the protection that the lawyer can have in a disciplinary proceeding. So there's really no reason to call if you don't have a question. There are no bad questions. And so no surprise here that the 2 biggest areas of the law where we see complaints are the areas of criminal law, family law, 2 both emotionally charged areas of the law. And so they're not happy when they come to you. And if you don't get them the exact remedy or the exact relief that they want, they get upset, but we understand. Year in, year out, we publish a most violated rules list, try to help lawyers. I don't care what your practice area is. I don't care if you're a trial litigator. I don't care if you're a bankruptcy lawyer. I don't care if you're a patent lawyer, an immigration lawyer. The number 1 complaint we get across all practice areas is communication. I'll talk a little bit more about that in a minute, but Rule 1.3, willful neglect, is also kind of a big ticket item that we see across most practice areas. And I like to point this out for willful neglect because there's a little bit of misunderstanding. The rule says willful neglect. So I oftentimes will get a call from a lawyer who's really upset, really distressed, and they say, Roman, I missed the statute, missed a statute of limitations, or I missed a deadline that's in a scheduling order, and my client's been punished because of my conduct, and so I want to turn myself in because I know it's an ethics violation. I say, well, tell me a little bit about it. And so what we uncover sometimes is that's the only problem they've ever had. And the reason they missed the deadline is because they were really busy. They were trying to do good for their client. It just slipped up on them. And I try to tell people, I say, well, the rule says willful neglect. And I don't know that rises to the level of willful. So this is probably not a bar violation. It may result in you getting sued for malpractice. So there may be consequences, but it doesn't always rise to the level of a bar violation. And then I'll talk a little bit more about some of these other ones as we continue through the slides. So again, some more rules that I'll talk about. But really, when I talk about communication, this quote really is what we see. The lawyer says, look, Roman, I texted my client. Look, Roman, I sent him an email. Sometimes that's perfect. Sometimes that's all it needs. But sometimes an issue is so important, you've got to pull the client in, you've got to look them in the eye, and you have to tell them what is about to happen to them, and just manage expectations.
And Roman, I know one size doesn't fit all. In today's world, there's so many ways to communicate with your client, but what would be your rule of thumb? If you were back in the practice of law, what would you do routinely to make sure your client could not adequately allege that you didn't communicate with them?
So the rule says that you've got to keep your client reasonably informed. And depending on what's going on in the case, if you have a judge that's issuing a lot of orders, and they're material to the representation, you probably need to be letting your client know about these orders. This day and age, all you have to do is email the order. You don't have to necessarily print it out and send it. And so depending on what's going on in the case, the other problem we see sometimes is maybe you have a motion for summary judgment pending, motion to dismiss is pending, and there's really nothing that can go on in the case until the judge rules, and your client just doesn't understand that. In those types of situations, it's good to explain that to your client, that this is where we are. We can't really go forward and do anything else. It may be 3 more months under those circumstances, because there's really nothing to update the client on. I wouldn't let it go more than 3 months, just kind of update the client, say, look, the judge still hasn't ruled. We still can't do anything. And so just make sure you're managing expectations. A couple of additional thoughts, though, on client communications. Make sure your client knows how to communicate with you, but it's okay to set appropriate barriers. This day and age, you have a lot of lawyers, particularly young lawyers, that feel like they've got to be on all social media platforms. They have to constantly be responding to their clients. We call that the 24/7 lawyer in my office, and that is a sure path to burnout.
Right.
Also, be careful contacting your clients through social media, because sometimes your clients don't want people to know that they have a lawyer, they're talking to a lawyer. And then, some sage advice also is, look, your clients are very emotional. You don't need to become emotional like your clients. I mean, your clients come to you for the objective advice. Just try not to be emotional, because don't risk your livelihood over their case. It's not worth it. And so let me talk about another thing that we see. And we're talking about emotional issues. Oftentimes when lawyers come, when people come to see the lawyer, it's an emotional issue. It's the most important thing going on in their life. And the lawyer takes on that case, and they really are trying to help the client. And sometimes things get muddled and things get gray and things cross the line. Under our rule 1.8, prohibited transactions. Now, I have no idea why they put this under prohibited transactions, but most people know this. You can't have sex with your client. And not only can you not have sex with your client, you can't have sex with mom or dad. So you may represent little Johnny, little Susie. You can't get involved with mom or dad. And under this rule, if that relationship doesn't go all the way, then the person gets upset. They tell the bar. The rule says the presumption is that the lawyer exploited, and so it is a rebuttable presumption. But this is another one of those situations where we see things get really emotional, and lawyers risk their law license over something that really shouldn't. When we're talking about some other kind of big ticket items, I try to remind people with 3.2, expediting litigation is a situation where most lawyers understand this rule. It says a lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the clients. And so I have these conversations with criminal defense lawyers that say, look, Roman, my client's going to jail. All right, it's in their interest to never go to trial. Or maybe a civil defense lawyer. The lawyer says, hey, Roman, my client's got some clear liability. We're going to have to pay some money in this case. It's in our interest to never go to trial. Well, I tell them that under the committee comments, those are not justifiable excuses. So if you look at the yellow highlighted portion, it says, nor will a failure to expedite be reasonable if done for the purpose of frustrating an opposing party's attempt to obtain rightful redress. And then the other highlighted portion says, realizing financial or other benefit from otherwise improper delay in litigation is not a legitimate interest of the client. So your client may be going to jail, your client may have to pay money, but that is not an excuse. That is not consistent with the interest of your client. And here's the reason. The policy reason behind this that underpins this rule is that our system of justice is predicated on our citizens of this country believing that if they are a legitimate victim or they have a legitimate injury, that there is a fair, impartial, and efficient system that will deal with that. And if there's not a fair, impartial, and efficient system to deal with it, well, then they'll deal with it on their own. They'll take justice to the street. Certainly, that's not in anyone else's interest. A few other things that we get questions on are can an Alabama lawyer be sanctioned for private conduct? I'm doing things in my own life, and I know you and I both have seen this. We see where a lawyer's been arrested. We had a lot of situations where you had a lot of a part of the Black Lives Movement. When you had during a lot of the uptick on that, you had a lot of social protests, you had a lot of counter protests. And so you had lawyers who were very involved in some of these issues. And sometimes they were getting arrested. And it was people on both sides, and so we would have to caution them, say, look, I understand that this country has a strong history of protest, but you are a lawyer and you will be evaluated differently than just a citizen who's not a lawyer.
And you mentioned social media earlier. That's where a lot of lawyers can get in trouble.
Absolutely.
You don't get to take off your lawyer hat when you go to Facebook.
That's true. So when we prosecute these cases, we prosecute them typically under Rule 8.4. The D subpart says it is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. Oftentimes, those are issues where lawyers are getting involved in cases that are not their own case, but they are social issues of the day. And then 8.4G, it is professional misconduct for a lawyer to engage in any other conduct that adversely reflects on his or her fitness to practice law.
That's kind of a catch-all.
It is a catch-all. It absolutely is a catch-all. And so some examples under 8.4G are attorneys getting arrested. They have a little too much fun after an Alabama or an Auburn game or a Troy game, and so they get arrested. Certain social media outbursts. Saw a lot of this during COVID, where people were very upset about some of the city ordinances, the mask ordinances, and they were taking to social media and really, telling people, look, you don't have to comply with the law. I'll represent you for free. Those types of things. And then really any other outrageous conduct, although it may not be subject to a criminal penalty, may still get you in trouble with the Office of General Counsel. Let me talk about what, David mentioned this at the beginning, what we've been spending a lot of our time on the last 6 months, and we're going to really talk about this a lot more over the coming year, is kind of this intersection between the practice of law and technology. Now, emails came out when I was in law school. And so I kind of was on the front end of that and, didn't really fully understand it. But, a lot of people didn't want to use emails. They didn't use computers. They didn't like computers. And they said, I don't want to use emails. But, now you have to have email to practice law. You've got to have email to file stuff with the court, to receive stuff from the court. And every now and then there are these technological changes that occur in the practice of law. And then once they are adopted, we never go back. And so let me talk a little bit about that. We really are living in a virtual world. And one of the big changes occurred really post-COVID. The United States Supreme Court, probably the most traditional institution in American jurisprudence, when they are conducting their business in a way where no justice is in each other's presence at oral arguments, where the litigants who are arguing very important cases before the court are not in each other's presence. That is a marked shift in the practice of law. And so when the United States Supreme Court adopts to trends of the day and they deal with their business in a way, that means the rest of us as practitioners have to change and learn to adopt the same way. We've seen a lot of courts, a lot of your local governments adopt these changes, but really we have a lot of people who are still afraid of technology. They just don't want to deal with the technology.
Roman, what does the bar do to assist those that aren't tech savvy?
So we do a couple of things. One, we talk about CLEs like this. And of course, my CLEs really are talking about people's ethical obligations to know the stuff, but the bar has a lot of other programs. We have a practice management assistance program, Chris Coley is the director of that program. He's very tech savvy, and he does a lot of CLEs on really the deep dive and the bullet points on what are the various technological products out there, what are the best practices, and these are some of the things you might want to consider. So the bar has some of those CLEs on our website, and then you can always call Chris. Let me tell you this about Chris too. The Practice Management Assistance Program has the same confidentiality provision that the Office of General Counsel does when we give you ethics advice. And so if you call Chris and you've got a problem and he uncovers some underlying conduct that is a violation of the rules, he's also prevented from turning you into the prosecution. Again, another kind of safe harbor that the Alabama Supreme Court has inserted to encourage lawyers to get the help that they need. You know, really the ethical hook on our ability to tell you that you've got to maintain your proficiency in technology is Rule 1.1. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. So if you undertake a case, you really do need to be able to master all that is required to properly represent that. So if you unpack it, competence equals knowledge. That's knowledge of technology. All right. Competence equals skill. You know, that's the ability to get exhibits admitted remotely. How are you going to get an exhibit admitted or authenticated if that witness is not in your presence and you can't reach over and hand them a document? How are you going to do that? And those are the types of things that you have to know. There's also public support for technological change. You know, it's not just the court. It's not a top-down approach making lawyers change the way they treat their clients. The public expects this. I bet many of you are getting paid by Venmo. I bet many of you are getting paid by some Cash App. You know, some of your clients, they don't want you to send them, they don't want you to mail them a letter through snail mail. They want you to send them a calendar. They want you to text them or something like that, or set up a Zoom call and deal with them. And, you know, that's part of our job, is to meet our clients kind of where they are technologically. There is a downside to technology. You know, we've been spending a lot of our time talking about data breaches. You know, we started talking about data breaches in 2017, basically saying that it doesn't matter the size of your practice. I don't care if you're a solo, I don't care if you're in a big firm, there's a very good chance that you're going to be the subject of a data breach or an attempted data breach. And then the 2022 data that we have really just reemphasizes what we were telling people in 2017. Doesn't matter the size of your law firm. This is something that you need to be thinking. And the data also, you know, highlights that most of these attempts, these data breaches, are external breaches. It's not your clients necessarily, not your employees. These are very sophisticated hacks externally, because they're trying to get the valuable information that you have on your clients, and oftentimes they're trying to get to your trust account.
Right.
So the American Bar Association tried to get in on the front end in 2017. They issued an opinion that said, look, if you're going to quit having hard files and you're just going to store information electronically, you've got to do it in a reasonable manner. Of course, when we look at these cases, the question always is what's reasonable, you know, under the circumstances. And so, you know, some of the things might be, you know the software you're using. If the manufacturer who created the software that you're using is no longer in business, you might want to change software. You know, there's some things like closing out your computer when you leave, you know, not clicking on suspicious emails, things like that. Some things are just common sense. But, you know, the ABA came back a year later and said, look, this data breaches are so prevalent in the practice of law that lawyers now have an affirmative duty to have a data breach plan. What are you going to do when you are hit with ransomware and you're locked out of your system? How are you going to restore your systems? How are you going to let your client know what information was taken and how it was taken, so that they can turn around and protect themselves or protect their business? And so those are things that you really need to be thinking about. You know, the Alabama Bar Association has not adopted this opinion yet, but I do think you'll probably see a formal opinion from the Alabama State Bar in 2024 that really mirrors this opinion. And then, independent of your ethical obligations, depending on your practice area, you may have certain statutory obligations. You know, Alabama did pass the Data Breach Notification Act. That's a model act that's been passed in a lot of states. It does apply to lawyers and it does apply to law firms. So independent of your ethical obligations, you may have certain statutory legal obligations to protect information in certain ways. The other thing that we've seen kind of post-COVID, I know y'all probably dealt with this. You have a lot of people who are very efficient working from home. Right. COVID kind of you know, demystified that concept that people can't work from home and still be efficient. We have a lot of people that can do that, that are trying to do that. You the problem is that you have the same security obligations if you're working from home as you do if you're working from the office. And what we know is that your home systems oftentimes are a lot more vulnerable than what your systems are if you're working from the office. And really what we talk about when we talk about data breaches is client confidentiality, trying to protect your client's information. The ethical hook there is Rule 1.6, very straightforward rule. Says a lawyer shall not reveal information relating to the representation of a client unless that client consents after consultation or except for disclosures that are impliedly authorized in order to carry out your duty. They're pretty straightforward. The point I like to make when I talk about client confidentiality is your duty of confidentiality is much broader than the attorney-client privilege. We get a lot of questions, ethics questions about the attorney-client privilege, and I tell people, the attorney-client privilege is a rule of evidence, right? That rule of evidence is within the purview of your judge. We cannot tell you what is and is not attorney-client privilege. That is a legal determination based on the case law and the rules of evidence. But your duty of confidentiality covers things that may not be a violation of attorney-client privilege. So, for example, let's just say you represent a client that has got a criminal history. Maybe they've got a bad divorce. Maybe they have got some mental health issues and there's been a commitment. And some of those things are public because you can go to the public record, you can go to the courthouse, and you can see where those things have occurred. But that is information that is adverse to your client. That is information that your client does not want disseminated. And so you can't display those kinds of things or put those kinds of things in a brief or whatever unless you have your client's permission. So your duty of confidentiality is much broader than your duty under the attorney-client privilege. And other things, these are some kind of technological concepts. Most of you probably know what metadata is. When you create a document in its native form, whether that be a Word document, an Excel spreadsheet, or something like that, oftentimes there is data in the document where you create it, who's looked at the document, who's opened it up, who's edited it. And then sometimes when you use the same document as a form and use it for multiple clients, then each time you use that as a form, the information you input into that document still exists. And so in discovery, if you are giving documents in their native format, sometimes you may inadvertently disclose confidential information. Sometimes that's exactly what you want to discover. That's the type of information that you're trying to get. And so you should be giving documents in their native format. Sometimes it's not. And so you should not be exchanging documents in their native form. Where else, when we're talking about technology, we're talking about client confidentiality, where else do you find confidential information? How about your copiers and your printers? All right. I bet every one of you that has a copier, has a printer, has a modern copier or printer that has a hard drive embedded in it. So every time you copy something or scan something, a copy of that goes to the hard drive. And so when your 5-year lease is up on that copier and you send it back to the person that you leased it from, did you wipe the hard drive? Because if you didn't, you just sent 5 years worth of confidential information to a third party that you don't control.
I bet a lot of our listeners are taking notes on that.
Yeah. And so, I do see people when I speak of these CLEs, it's usually at this point where I see people kind of look up above their laptop or their phone and they'll reach over and they'll write something down because that does come as a surprise to a lot of people. And then also, external hard drives, computers, iPads, you've got a laptop that you always use and that laptop just dies. Or you've got an iPad that you always use and the iPad dies on you and you just can't get it to work anymore. Well, you might not be able to get it, but I promise you there's a teenager or a college kid out there that can get that iPad or they can get that computer to work. And so you can't just discard those any way you want. You need to make sure that those are cleaned or are discarded in a way that's not going to risk your client's confidential information. And then outsource billing and word processing. You have a lot of lawyers now who outsource parts of their practice, and that's okay. Create efficiencies so that you can spend time on higher value work, so that maybe you can make a little more money. But some of your outsourced billing and word processing has confidential information in it, and you need to be getting your client's permission to send their confidential information to a third party so that they can do that kind of work. A few other things that I want to point out is under 5.3, lawyers are responsible for the information that they outsource. So if you hire a third party, you're ethically responsible for it. One of the things I like to point out under this rule, because I didn't really appreciate it until I got this job, is under the A subpart of this rule, a partner in a law firm has to make reasonable efforts that the firm has certain policies and procedures in play. And so it's pretty intuitive. It's pretty straightforward that the lawyer who hires the third party or hires the non-lawyer assistant is going to be responsible because they're the one supervising. But a partner in a law firm can be held liable if the firm itself doesn't have mechanisms and protocols in how you deal with non-lawyer assistants. One other point I want to make on this rule is the American Bar Association has recently changed this rule, and they've changed the title of it. And so the current title of this rule in Alabama is responsibilities regarding non-lawyer assistants, so individuals that assist you. The current ABA change says responsibility regarding non-lawyer assistants. So that last word would read ASSISTANCE. And the reason they made that change is because there are a lot of non-lawyer assistance that occurs not from individuals, but from computer products, from technology. And so we'll talk a little bit more about that now. So artificial intelligence is something that we are spending, we being the Office of General Counsel, and really Office of General Counsels around the country who work for bar associations are spending a lot of time talking about artificial intelligence and how it impacts the practice of law. So really what we talk about is generative AI, not just artificial intelligence, but a specific type of artificial intelligence called generative AI. And artificial intelligence has been around a while, but generative AI has the ability to create original, authentic content. And that content can be words, paragraphs, documents. It can be images. It can be audio. It can synthesize large volumes of information, really create a lot of very persuasive information. And so the question is, well, who's using generative AI? Well, a lot of your clients are using generative AI. You have a significant number of lawyers who are starting to look at the products, and then you've got over half the lawyers that say, hey, I'm going to start using those in my legal practice. You've got law schools that are teaching on. So, not all law schools, but I think most law schools are probably talking about certain AI products. Like I mentioned, when I came out of law school, I was using email. A lot of lawyers weren't using email, and I knew how to use email in my practice. So a lot of people who are coming out of law school now or about to come out who are going to compete with you for business, they're going to come out knowing a lot about this artificial intelligence. And so if you are a lawyer and you don't know anything about generative AI, then you need to start right now. It's really that important. There are criminals who are using it. That's not a surprise. Again, very sophisticated scams that are being perpetrated on lawyers, being perpetrated on clients. I'll talk a little bit more about that in a second. There are a lot of products out there, and I'm probably not the best person to tell you about what all products are out there. Again, I mentioned Chris Coley, who runs our practice management assistance program. He's very knowledgeable. Our communications director, who's wonderful, a woman named Melissa Warnke, also has a very good knowledge about what kind of products are out there, and she's a very good resource if you have any questions. This is a product that's not designed specifically for lawyers. This is IBM's product. Very impressive, as you would think anything IBM puts out is, but it is geared really towards business people. But there are a lot of specific AI products designed just for the law. Lexis has a very impressive product. I'm not getting paid to promote this product, but it is a very impressive product that you should probably consider. Not surprisingly, Elon Musk is getting in on the artificial intelligence bandwagon. He was on early with ChatGPT, which we'll talk about a little bit in a minute. He got out of that, and I think he's a little upset that it's getting most of the talk right now. And so he's got this product out there, and I'm sure if he's associated with it, it'll probably be a pretty good product. And then there are these other products that are out there that are built on existing platforms. So, for example, I mentioned ChatGPT, and again, I'll talk a little bit more about that in a minute. ChatGPT is a product that operates a lot like Google, where you enter in a search and it will give you a response. Well, this is the Do Not Pay app. All right, the Do Not Pay app is kind of built on ChatGPT. It markets itself as the world's first robot lawyer. It says the Do Not Pay app is the home of the world's first robot lawyer. You can fight corporations, beat bureaucracy, and sue anyone at the press of a button. And so, this is kind of some of the stuff that we're faced with, because you got lawyers who are using this, but you have your clients who are out there using this. So you've got a client that's going to come see you about a problem, but they've already used the do not pay item. So they already have this working knowledge. Now, some of it's incorrect information, which is going to create a more problem for you. I mentioned rule 1.1, your duty of competence, your ability to stay competent on technology. Another piece of that is your clients are going to be coming in wanting legal advice, and they're going to have used some of these products, and you're going to need to understand them so that you can kind of correct their misunderstandings, or at least persuade them that your information is certainly a lot better than they get from the do not pay. Also, you got to be careful when you're using artificial intelligence products, that some of it is just ripped off information that is copyrighted or is patent protected. And if you push that information out or include it in some of your briefs or whatever, you may create some criminal liability on yourself. Google has a product, not surprising, but again, what everybody's talking about is ChatGPT. Gibson, have you used ChatGPT?
No, I'm not. Does that surprise you?
Well, not really.
I have dealt with the lawyers that I thought were robots.
Yeah. Well, you also have a very smart son who I know has used ChatGPT, because he was the one telling me about it, I believe, when about a year or so ago. I think he's the one turned me on to it. But let me talk a little bit more about generative AI and ChatGPT. So again, ChatGPT is a product, and I'm going to talk about this because this is really what everybody else is using and talking about. There are two versions. There's I think version 3, which is free. I think version 4 is a paid version, but they're both very, very persuasive. And so one of the reasons people are using them is because when you ask ChatGPT a question, it gives you a response, which is very impressive. It's very organized. It can do a lot of different things. So, things that it would take you, hours, weeks, sometimes years to summarize, it can do almost instantly, or at least give you a very good working draft for a summary that you can, kind of build out. Very impressive stuff. For those of my, brethren that do work as outside legal counsel, I tell them, I'm sorry, because I know a lot of the legal departments, corporate legal departments around the country now are using them to monitor outside counsel. If you're outside counsel and you have a legal strategy and you're trying to convince your client that this is what you should do, they're running reports. They're looking at their own analytics. They're looking at ChatGPT, and they're making decisions based on the analytics that they get. I have lawyers that will submit their bill, and then their bills are being cut because of some of these analytics that they're getting from ChatGPT and some of this. And so, that's a problem. It's a problem that we're trying to help a lot of the lawyers with, because a lot of times that rises to the level of the unauthorized practice of law. But I'll talk a little bit more about that in a second if we've got a chance. Let me give you a little flavor of what I'm talking about. This is really some interesting stuff. So again, ChatGPT, a lot like Google, you can ask it to do specific things or give you specific information, but really the difference is what you get back. So in this particular example, and this was an example that appeared in the American Bar Association Journal. In this example, the American Bar Association asked ChatGPT, "Hi, ChatGPT, what can ChatGPT do for lawyers in 100 words or less?" They could have said 200 words, 500 words, in 100 words or less. What can ChatGPT do for lawyers? Then, of course, the response they get is, as an AI language model, ChatGPT can provide assistance to lawyers in various ways. And then it talks about all the various ways and all the various things that ChatGPT can do. Very organized, very efficient, very straightforward, some very persuasive stuff. Then they ask him a second question. They ask ChatGPT, is ChatGPT trying to take lawyers' jobs away in 100 words or less? And of course, the response there is no, ChatGPT is not trying to take lawyers' jobs away. Instead, it can assist lawyers by providing them with a powerful tool to enhance their work efficiency, accuracy, and productivity. And you see the rest of the response. Looks like it was written by the legal department of ChatGPT. Very straightforward, very useful information, right? It's not just a bunch of information that you can't use. Most of it is relevant information. But here's the thing about ChatGPT. You can ask it a question, it gives you some information, and then you can ask it about the information that it just gave you. It's very iterative. You can ask it to refine or to expand on whatever it gives you. And in this particular situation, the American Bar Association Journal said, all right, let's take what you just gave me, but say it in a rhyme.
Oh, wow.
And so ChatGPT almost instantly looks at what it just said and then created a rhyme. And then the rhyme is this: ChatGPT knows its limits well. It cannot replace lawyers with its spell. for only humans can bring the skill of judgment and experience to fulfill. So fear not, lawyers. ChatGPT is your friend. It's here to assist and help you to the end. That's some really scary stuff.
Correct.
I've heard people, they'll go to a funeral or they'll go to a colleague's retirement party and they want to say something nice about the person. And so they will input a lot of information about this individual, their dates of birth, some of the things they like, and they'll ask it to spit back a poem. And sometimes they'll say, write it in a haiku, write it in a sonnet. Any format that you want it in, ChatGPT can do those types of things. And so it's really impressive. And so when I first read this in the American Bar Association Journal, this last sentence kind of stood out to me. It said, it's here to assist and help you to the end. And of course, it occurred to me at that point, to the end of what? To the end of humanity. But look, as good as some of the stuff looks and sounds, some of it is false. It's just blatantly wrong. Some of it is misleading, which means that some of it is accurate, but they are missing material key parts. Some of it is discriminatory because the people who input the data and input the images didn't really understand what they meant. Some of it is just plagiarized. And then the other problem is you run the risk of disclosing confidential information. And I'll talk a little bit about that in just a second. As a practice point and kind of where we're headed, this right here is not the standard, but this is an example of what you're going to be faced with in the future. Now, we've all seen those memes where you have President Obama talking to President Trump, who's talking to President Biden, and they're saying some really funny, humorous things on social media, and it's really not them. And everybody knows it's not them, but it kind of sounds like them, and it certainly looks like them. Those are called deep fakes. And with this technology, you can really create very impressive deep fakes. Where this is going to be a problem for lawyers, or it's going to be when your client comes to you and they give you a picture and they say, look, this proves my case. Or they show you a video that says, I took this off my camera, off my security camera, or I took this off my phone. Or they give you an audio that they say was a voicemail left. And you're going to have that. And it's not going to be correct because your client will have created. And then probably more importantly, you're going to represent a client and the person on the other side is going to do that to you. They're going to say your client is wrong because I have this picture that proves my client's theory of the case. And how are you going to be able to attack and defend your client when someone else is offering you a deep fake? And again, that's not the standard now, but that's stuff that you're going to have to deal with in the future, which is another reason why you kind of stay up with the technology and you got to stay up with the trends. And as the father to 3 daughters, this kind of scares me that in the wrong hands, people can do some very real damage, some long-lasting damage, some very long-lasting damage that will follow people around for a long time. And you as the lawyer, you can't get sucked in on this stuff, on some of this stuff, because if you are promoting something, like say you get some images and you get some fakes, and then you push those out there either on your social media feed or you push them out there in a brief that's can be gotten online, then you're just kind of compounding the problem. And again, this is not the standard right now, right? We're not prosecuting people over these things right now, but this is coming. And these are things that you're going to have to start considering. I don't know anybody in Alabama that's been sanctioned, but there have been a couple of lawyers around the country. This is a lawyer up in the Northeast who, in a lawsuit, cited 6 cases using ChatGPT, and those cases just didn't exist. Right. I try to avoid legal research where I can, but when I do, I usually go to the tried and true method of Westlaw and Lexis. I don't go to ChatGPT, although ChatGPT is good on a lot of things. You probably shouldn't be using your legal research with it right now. Ultimately, this lawyer was sanctioned. They did have to pay a $5,000 fine and write a letter of apology. Fortunately, in this case, the client wasn't harmed. Judge Vaden in the U.S. Court of International Trade has pointed out that if you're using ChatGPT, that really what you're doing is you're having a conversation with ChatGPT. And this is an important point. ChatGPT is a limited data set in the sense that the data that has accessible, that's inputted. Well, the data that's accessible cuts off in some date in like 2022, I believe. And so the problem is when people go to ChatGPT and they input questions, they run the risk of inputting confidential information. So for example, if you ask ChatGPT a question, that question becomes part of the data set. And if you keep refining your question, you may ask specific questions that are specific to your client And you may inadvertently disclose some confidential information or some fact patterns that are very specific and very confidential to your client. And if you do that, they become part of the larger data set, which means that if someone else enters a similar search term, that information could be pushed out to them, and you can inadvertently disclose confidential information. You have Judge Starr in the Northern District of Texas that says, look, you as the lawyer take an oath, you agree to put aside your prejudices, put aside your biases, and you represent your client faithfully. But these artificial intelligence products don't do that. All right, they don't take that same oath to put aside biases, to put aside prejudices, and to be truthful. Judge Malloy is so frustrated with it. He just says, I'm not dealing with it. You're not using ChatGPT in my courtroom. And so ChatGPT is prohibited. And so this is a practice point, right? If you have a multi-jurisdictional practice, if you just practice in one jurisdiction, you probably know the rules. You probably know the local rules. You probably know any judge's standing orders they have. But if you have a multi-jurisdictional practice, probably one of the first things you need to do is to see if there are any standing orders or any local rules that specifically talk about AI. I will tell you this, that a lot of courts around the country now have issued standing orders, have issued local rules. The Fifth Circuit Court of Appeals is taking comments on a rule change right now. I think the deadline is early January, and they plan on rolling out a rule. And so in the Fifth Circuit, like some other district courts, if you use any AI product in drafting a brief, you have to certify in that brief that you use the product and that you have verified the information you derive from that product. And then independent of that certification within the document, there's a separate document the Fifth Circuit will more than likely require that you have to mark whether or not you used AI, period. And so those are the types of things that we see the courts moving towards to address some of these issues. And so you as a practitioner have an ethical obligation to follow, the rules. And so you need to make sure that you're doing them. Some of the other rules that we that really are implicated by AI. I mentioned the rule on competence. You have to be competent, which means you have to have a working knowledge of some of this technology. But the other problem where we see competence in AI is some of these products are so good that you have lawyers saying, you know what, I've never filed a bankruptcy case. I've never filed an employment discrimination case. Maybe I will, and I'll just use ChatGPT as kind of a backup. And they take the case, they get involved in the case, and they just aren't doing what is required of the case. And so they feel a little emboldened by some of these products. And so that's another issue of competence. I mentioned Rule 1.6, the rules on confidentiality, that you may run the risk of inadvertently disclosing some confidential information by using some of these products. Rule 3.3, candor towards the tribunal is implicated. Obviously, if the information that you're receiving is false and you put that information in a brief, well, then that's not being very candid towards the tribunal, because you have an obligation to really stand behind your documents and what you're putting in the documents. Now, the rule 3.3, candor towards the tribunal, doesn't say that you have to know personally all of the information is accurate. So, for example, your client gives you information in an affidavit form. You don't know if that actually happened. What you know is that it's reasonable that the evidence is what it purports to be. But some of the information that we're getting from ChatGPT is just wrong, and the lawyer doesn't really do any additional verification behind that. So that can really get you in trouble. Rule 1.4, communication. There, you've got to keep your client reasonably informed. But the B sub part of Rule 1.4 says that a lawyer has to keep their client up to date on things that are material. And so which basically means that if you've got to understand a thing so that you can turn around and tell your client. And if you don't understand it, how are you going to be able to explain to your client kind of what's going on in the case? Rule 1.5, fees. I read an interesting article on this. And again, this is probably not the rule right now, but this is certainly going to be the rule. If you look at Rule 1.5, there are about 9 factors that you've got to consider when you're setting your fee to make your fee reasonable. Those factors come straight out of the case law, and almost every jurisdiction has very similar factors. But some of the factors are the novelty of the issue, or the amount of time it's going to take to handle the case, or the experience of the lawyer. The experience of the lawyer has always been very important when you're submitting a fee petition, because typically the lawyer who's more senior can justify the higher fees. Well, in a case that is driven by technology, Sometimes there are efficiencies, so you're not going to spend a whole lot of time on it.
Right.
You know, may allow you to take some cases that you otherwise wouldn't take because you can be more efficient. And then sometimes in the right case, a case that is technologically driven, maybe there's a discovery issue, there's something that's very tech intensive. It might be the younger lawyer who understands the technology better, who's having to handle the hearings and talk to the special master and those types of things. They can justify the higher fees in the fee petition. You know, I've seen a fee petition where someone submits a fee, and one of the criticisms of the fee petition is that the lawyer is not as learned, has not been practicing law as long or whatever. And then the response was, look, this was a tech case, and I'm the smartest person in this case, basically, on tech. I thought it was pretty creative. I'm not sure that I would go out and say that I'm the smartest person in the room on tech, put that in your brief, but I thought it was kind of effective. It was pretty interesting. I mentioned Rule 5.1 and 5.3 supervision. You know, maybe you don't understand the technology. You say, look, but I've got this great associate, and I'm just going to delegate this task to the associate, and that's fine as long as the associate gets it right. But ultimately, you can be still held accountable as the supervisor. And then the unauthorized practice of law. We see a lot of corporate legal departments, you know, a lot of adjusters, people who aren't even lawyers, who are trying to dictate to the outside counsel what they can and what they can't do. They can't take depositions. You know, they can't file these pleadings. And the basis is because we've run these analytics, or we've used ChatGPT for our legal strategy, and it says these are the things you need to be doing in these types of cases. And sometimes that's okay, but sometimes it's not. Sometimes it rises to the level of the unauthorized practice of law. In Alabama, the unauthorized practice of law is a crime. So you can really, really get in trouble. So, you know, I think we're running out of time. David, do we have any questions? I think we do. I think I've seen some pop up.
We do. And look, on behalf of all the viewers, I want to thank both of you for a really great presentation. And yes, we have received several questions during your talk. And if you'll allow me, I'd like to present them to you, get a little bit of feedback from you guys. So our first question comes from James. James asks, can you give us a little better definition of native data?
Yes. So native data is usually what is, well, it's a native format. So when you have a document in discovery, you ask for a document. Sometimes they just want an email because they want to know what the email says. And so you print out the email. And so that email is not a native document. But if you go into Microsoft and you download the actual text file, then that has a lot of information embedded in it, like who created it, who viewed it. You know, so it's not just what it says on the piece of paper, it's what's embedded in the document. And so sometimes that becomes relevant, sometimes it's not. And so if you are using a document and you create a form, let's just say you're trying to reach a settlement agreement, or you're trying to craft an agreement with opposing counsel, and you are submitting a Word document to opposing counsel to consider instead of a PDF version of that document. Well, if you submit the native document, which is the actual Word document, not a PDF version, then sometimes there may be confidential information in there, some information on prior drafts, some information, you know, maybe it's not just your client reviewing it. Maybe there are other interested parties that your client is running that through, that they viewed it. And sometimes you can tell that information and it exists in the native format. Now, sometimes in discovery, that's exactly the type of information you want in your discovery request. And that is pinpointed. And what we tell lawyers is that's okay. You need to get a protective order. You need to, you know, obviously authorize it, talk to your client about those issues. But sometimes that is not the information being requested. And so you shouldn't inadvertently disclose that type of information.
Thanks. That's very helpful. Next, we have a question from Hansa. And Hansa wants some clarification on this ban on any AI product use. Would that include the Lexis and Westlaw AI products as well?
So that's a really great question. You know, Judge Malloy is the only one that I'm aware of that is strictly forbidden it. And he specifically says ChatGPT. You cannot use ChatGPT. And so it's going to vary based on the standing order of the local rules. I would be very shocked if there was an outright ban on all AI products because some of the products are useful. You know, the product like that Lexis has, it's a product designed by lawyers for lawyers, and their database, as you would expect, already comes from their case law. I think they have some other add-ons and some other databases that they incorporate, but a lot of the information is information that they already have, and it's information that's kind of an industry standard, if you will. So I don't think that there would be an outright ban on all AI products, but again, you're going to have to review local rules and standing orders of different courts to be able to make that determination on your own.
All right, next we have a question from Lori. Lori asks, for a solo practitioner, do you recommend that they add language to their retainer agreements allowing them to share client names with that lawyer's CPA when they send documents such as billing?
I think that's a great suggestion. I think not only should they put that in their retainer agreement or their engagement agreement that, we may use your personal information, or some of your personal information may be provided to our billing agent, or whatever, if that in fact is the case. And I think even I'd go one step further and make sure that the person understands that and initials that specific provision in the engagement agreement. I think that's a great practice point, great tip that she illustrates.
Got an interesting comment from Tom. Tom asked the bar to please consider when making any rules for artificial intelligence, keep in mind that that appears in a lot of products, not just Chat GPT. Even some word processing apps may be using it now.
So that question just popped up on our end, and I will say this: Tom Monk was my trial team partner in law school, and he is very tech savvy. He carried the weight for us in law school, so it does not surprise me that I would get that question from him. But he's exactly right. And I'll tell you this: we had a committee that met on Monday. The bar is really starting to put together some best practices. You have two of the bar associations that's already kind of put out some early rudimentary type things, but the state bar is going to put out some rules. And he's right; it's not going to be specific to Chat GPT because there are a whole suite of products that are out there being used right now.
Thanks. That's very helpful. I'll tell you, as I listened to your presentation today and your discussion about Rule 1.1 competency, particularly in the context of technological proficiency, I kept thinking to myself, back in the day, the mentoring process between older lawyers and younger lawyers was really a one-way street. The older lawyers conveyed the wisdom and the young lawyers just sat there and listened. But, as legal technology has evolved, I know I have to look to younger lawyers in our firm for a lot of mentoring. And I just wondered, is that something the young lawyers section of the bar could maybe spend some time focusing on, is putting together mentoring programs for us old dogs that need to learn new tricks?
So we have a very robust, that's a great question. It's not something that I've thought about. I will say that historically, Alabama has had a very robust young lawyers program, something that we spend a lot of time and resources on at a bar level, and they do a great job. And you have a lot of leaders of the bar, a lot of leaders within the state of Alabama legal community that have come out of the young lawyers program, and they do a lot of their CLEs. And they spend a lot of time putting those together because they try to put out relevant content. And I do think that's something that they might consider. And so I will let the current president know about that. And so maybe you will see something like that. I think that's certainly worth their time.
That'd be great. I tell you, because as an older lawyer, I would absolutely show up to any discussion by the young lawyers section about technology, because those are the folks in the bar that really have a handle on modern tech. And so that would be great. Well, Gibson, Roman, I can't thank you guys enough for being here today. And for those of you who may have missed our earlier announcements, by the end of this week, you're going to receive an email with an evaluation form. You're going to get an updated set of the PowerPoint slides that were presented today, and you'll get a copy of the video link to today's program. Please email your completed evaluation form to webinars@beasleyallen.com. Again, for those of you who are participating by phone, please email us your name, phone number, and state bar ID number to webinars@beasleyallen.com. That helps us ensure that you get full CLE credit. Also, be sure to check out the events page of our website, beasleyallen.com/events. We're going to have a really great lineup of shows for 2024, and we hope you can join us. Again, thank you for being here today. Thanks for supporting this webinar series. And we look forward to seeing all of you again next year.